For the U.S. Supreme Court siding with Jack Daniels today. The whiskey brand claimed that a novelty dog toy parodies their iconic bottle and paints the company in a negative light. Today's decision allows the liquor maker to revive its trademark lawsuit against the maker of the toy, which is called VIP Products.
And Michael Grinberg is a professor in DePaul's College of Law with an emphasis on trademark law. He joins us now to discuss the case. So lower courts had dismissed Jack Daniels' lawsuit based on something called the Rogers test. Can you explain what that is and why the Biden administration has actually called for its discontinuance?
Sure. The Rogers test is a test designed to handle trademark claims in situations in which a defendant is making a creative or expressive use of the mark. So the classic example is, I don't know if you remember the song Barbie Girl by the band Aqua. So Mattel sued the band claiming that the song Barbie Girl was trademark infringement. But Barbie Girl was also a song. It was a work of, let's call it art. And there are First Amendment issues with saying that something like that is illegal under trademark law. And so what the court did was they employed the Rogers test, which asks, is this artistically relevant? Is the use artistically relevant? And the name Barbie was artistically relevant to the song. And does the band do anything to explicitly mislead people about a connection with Barbie, which they didn't. And so that's the Rogers test. And the lower courts applied the Rogers test to the Bad Spaniels dog chew toy, saying that the artistically relevant use was to make a parodic reference to the Jack Daniels brand.
Okay, got it. So how does this decision, Michael, impact future parody commercial goods like that one?
Okay, so what's interesting here is that the court stopped short of saying that Rogers is out of the picture. The court said that Rogers is out of the picture if the defendant is using the plaintiff's trademark in a trademark way to identify and distinguish its own goods. And so the argument the court applied here is to say that the Bad Spaniels mark is not just a expressive reference to Jack Daniels, but actually is a trademark of the Bad Spaniels product. And so what the court said, if that's the case, then you don't get to use the Rogers test. You have to use ordinary likelihood of confusion analysis that would apply in directly competing products. If somebody tried to market a soda as Coca-Cola with a K instead of a C.
I feel like I'm so glad that I went into journalism and not law, because this is very confusing. But Michael Grinberg, thank you so much for joining us. You did a great job breaking it all down, and I'm so glad to see that you actually have the product in hand.
Thank you, sir.
I had to get it before it was off the market.
Right, thank you.